Hello and welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. In today's video, we'll discuss an important legal topic: who is eligible to make a will in India? We'll explore the qualifications, restrictions, and special conditions that apply when making a will under Indian law. Let's understand this topic in detail. 1. Legal eligibility to make a will. Under the Indian Succession Act, 1925, the law provides specific guidelines about who can legally make a will. A person must meet the following criteria. Must be at least 18 years of age. Anyone who is a major, completed 18 years, is eligible to make a will. This is because minors are not considered capable of making legally binding decisions regarding the distribution of property. Must be of sound mental capacity. The individual must be mentally capable of understanding the nature and consequences of the act. This means they understand what a will is, they know the extent of their assets. They are aware of the persons they wish to bequeath their property to. Must act voluntarily. The will should be made without pressure, undue influence, threat, or coercion from any family member or outsider. If the will is made under any external influence, it can be challenged in court. 2. Who cannot make a will. Not everyone is legally permitted to make a will. Here are the categories of people who are disqualified. Minors, under 18 years. A person below the age of 18 cannot make a valid will. However, in special cases, like for individuals under guardianship, the age of majority may extend to 21 years. Persons of unsound mind. Individuals suffering from permanent mental disorders, such as severe schizophrenia, dementia, or intellectual disability, are not allowed to make a will. Even a person suffering from temporary insanity or unconsciousness at the time of making the will be disqualified for that period. Persons under intoxication or influence. If a will is created while a person is under the influence of alcohol, drugs, or medication, making them unable to understand their actions, such a will is not valid in the eyes of the law. Coerced individuals. If someone is forced or threatened into making a will, or manipulated through emotional or physical pressure, the will can be declared invalid by the court. 3. Married women and their right to make a will. There is a misconception in some parts of society that married women cannot make wills. This is absolutely false under Indian law. A married woman can make a will for her self-acquired or inherited property. For example, if she owns property received from her parents or bought with her own earnings, she has full legal right to dispose of it through a will. Marriage does not restrict a woman's legal capacity. Being married does not mean the woman loses her right to make financial decisions or write a will. 4. Will by persons with disabilities or illiterate persons. One of the strengths of Indian succession law is that it gives equal rights to people, including those with physical or temporary challenges. The following individuals can also make a will. People with physical disabilities. Persons who are blind, deaf, mute, or physically disabled can make a will as long as they understand what they are doing. Persons with temporary illness or in weak physical condition. Even if someone is ill, bedridden, or in the last stages of life, they can make a will if they are mentally alert and capable of making decisions. Illiterate persons. A person who cannot read or write can make a will by giving oral instructions that are then written down by someone else and explained to them in a language they understand. They must affix their thumb impression and the will must be properly attested by witnesses. 5. Soundness of mind, a key legal condition. A major test for the validity of a will is the soundness of mind of the testator at the time of execution. The person must have the mental capacity to understand the following: what property they own. They should be fully aware of the extent and nature of the assets they are distributing. Who the beneficiaries are. They must be able to recognize and identify the people or entities they want to leave their property to. The legal effect of the will. They must understand that this document will take effect after their death and that it is legally binding. A will made during a moment of confusion, mental imbalance, or illness where the testator is not in full control of their decisions can be legally challenged. Important tip: if there is any doubt about the testator's mental or physical condition, it is advisable to record a video of the will being read and signed, or obtain a doctor's certificate to establish mental fitness. This adds credibility and minimizes future disputes. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. We have explained the topic of will in 6 parts, so for complete information, do watch the next video, How to Draft a Valid Will in India. Step-by-step legal process. I will see you again in the next video. Jai Hind. Jai Bharat.